Good morning, everyone. Judge Santana is here.
Morning. Good evening, rather.
Do we have counsel for the parties present?
Good evening. My name is Mohammed Twaib and I'm the senior counsel for the appellants.
Good evening.
Good evening.
Good evening. My name is Daniel SOAS Ibosa. I'm the junior appellant. Thank you.
Thank you. So,
hi, I'm Fatima Mazi and I'm the respondent. Unfortunately, I do not know where my colleague, Mr. Simon Osai, is. So yeah.
okay.
And Ms. Fatima, you are the senior counsel, right?
Yeah, I think so. I'm in the previously in the appellant's case, I was a senior. So yeah, but I think in the respondents, I normally I'm in the skeleton arguments. My colleague, Mr. Simon Osai, would normally take it was his arguments, but yeah, I do not know.
That's up to you. I mean, in this particular hearing, who is the senior?
Yeah, I guess it would be me. I probably would start off the argument.
Thank you.
So, Mr. Rodrigo will start with the appellant.
No, I'm actually a fellow judge.
I know. So that's why. If you're ready, so we can ask the appellant to start.
Yes, exactly. So, so first of all, have the parties allocated the time between senior and junior counsel, and how would you like to proceed?
Yeah, so let the senior counsel start. How much will the senior counsel take, if they can tell us? Who is the senior counsel for the appellant here?
They can tell us.
Mr. Twaib?
So, good evening, everyone. So, I'll be taking approximately 15
Who is the senior counsel for the appellant here? Twaib?
Yes. Yes, so I'll be taking approximately argument for my first ground of appeal.
Okay. So let's start.
May it please the court. My name is Mohammed Twaib and I'm the senior counsel for the appellants, Mr. Leith Payne. My learned junior, Daniel Osas Igbosa, is the junior counsel for the appellants.
Okay.
For the benefit of your honor. Sorry?
Let's start. Continue.
Okay, sorry. Yeah. For the benefit of your honor, I would like to state the facts of the case. The facts of the case are Clevity is an online platform where users can create an account and trade in cryptocurrency. And users need to have at least 50,000 US dollars to trade cryptocurrencies. Mr. Azrani and Mr. Leith Payne are both users of the Clevity platform. Mr. Azrani programmed Alpha to automatically buy a cryptocurrency called Yapple from Clevity at the best possible price. Whereas Mr. Lee Payne created an algorithm called beta, which is coded in such a way that if there are many users selling Yapple, then the program beta would sell it at an average price. However, if there are no users selling Yapple, then the program beta would sell it at a highly inflated price. So one day, Clevity's software underwent a routine upgrade, and as a result, Clevity wrongly excluded the market users who had less than $200,000 as a margin in their accounts, rather than $50,000 margin as intended previously. Ms. Razrani and Mr. Lee Payne were coincidentally the only users with margin in excess of $200,000. In the absence of any other users in the market, only Mr. Lee Payne and Ms. Razrani could trade in cryptocurrencies. Thus, Beta offered to sell Yapple at its default price, and Alpha agreed to buy it. The disputed trade was settled by the Clevity platform, which recorded the transfer of 100 Yapple from Payne to Razi and debited her account $250,000. When Razi discovered what had happened, she issued.
Just a second. If you want to bring some water.
No, it's all right. Thank you.
Welcome.
When Ms. Razrani discovered what had happened, she issued proceedings in the DIFC Court's Digital Economy Court seeking damages. Mr. Payne argued that there could not be a relevant mistake within Article 37 of the DIFC contract law. The Digital Economy Court dismissed both of Payne's applications for damages. Now Mr. Lee Payne would like to appeal on two grounds. I will be addressing Your Honor on the first ground of appeal, which is as follows. The first instance court made an error in concluding that because Clevity operated a distributed ledger with a node in the DIFC courts had jurisdiction over the claim by Ms. Razrani against Mr. Payne under Article 5, Section A, subsection 1B of the Judicial Authority Law. Your Honor, this concludes my first ground of appeal. My learned junior, Mr. Daniel Osas Egbosa, will be addressing the second ground of appeal, which is as follows. The first instance court made an error in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, Section 1, subsection A of the DIFC contract law, that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. Your Honor, I have two submissions to make, which are my first submission is the securities law of the Sultanate of Oman 2022 regulates financial contracts or debt instrument which are negotiable the securities law of the Sultanate of Oman 2022 regulates financial contracts or debt instruments which are negotiable and transferable, such as stocks, bonds, cryptocurrency, etc. My second submission is the appellant and the respondent do not reside within DIFC, and moreover, there is no express clause related to jurisdiction in their contract. For the benefit of Your Honor, I will begin with my first submission.
Please.
The security. Sorry.
You can continue.
Okay. Yeah. I will begin with my first submission. So, the securities law of the Sultanate of Oman 2022 regulates financial contracts or debt instruments which are negotiable and transferable, such as stocks, bonds, cryptocurrency, etc. Since my client, Mr. Leith Payne, lives in Oman, the Securities Law 2022 is applicable to my client, Mr. Payne. Article 1, Section C of the Securities Law defines the meaning of the term securities, which is any financial contract or ownership right or debt instrument which are
Counsel,
negotiable.
Apology for the interruption. So your submission, if I understand correctly, is that since one party was in Oman, then that attracts the jurisdiction of the Omani court.
I'm sorry, I'm not able to hear you clearly.
There might be some echo. So, you hear me now?
Can you speak like a bit louder?
Can you hear me now?
Yes.
Okay. So I understand that you're making submissions of Omani law.
Yes.
Is there a submission that the Omani courts, rather than the DIFC courts, have jurisdiction?
So according to the Omani law, the consumers who are trading in securities such as stocks or cryptocurrencies, they are regulated by the Omani courts. So, so if an individual in Oman who has the license to trade in cryptocurrency, he will be protected under the Oman law.
Yes,
So
this
Oman
I understand. I'm not saying that the Omani court will definitely not have jurisdiction, because they might find to have jurisdiction. It happens it's a fact of litigation that sometimes courts in multiple jurisdictions claim to have jurisdiction. But what I'd like to understand is, does that mean that the DFC courts, that these courts should decline jurisdiction? So in other terms, why is Omani law relevant under Article 5 of the DIFC Judicial Authority Law?
I'm not okay, so I'd like to clarify that I'm not saying Article 5 of the Judicial Authority Law is relevant to Oman. What I'm trying to say is that if since my client, who is Mr. Leith Payne, since he resides in Oman and the whole transaction took place outside DIFC, since both the appellant and the respondent, both Mr. Leith Payne and Mr. Razrani, they both live outside DIFC. So Ms. Razrani lives in Dubai, outside the DIFC area, and Mr. Leith Payne, he lives in Oman. Since they both live outside DIFC courts do not have jurisdiction, since when they bought and sold cryptocurrency, in their contract they did not expressly state that in case of a dispute DIFC courts have jurisdiction. So in their contract it is not expressly stated that in case of a dispute DIFC courts have jurisdiction. So there is a matter of ambiguity related to jurisdiction, and I am arguing that in the favor of Mr. Payne by stating that DIFC courts do not have jurisdiction because Mr. Leith Payne lives outside DIFC, and also Ms. Razrani, and both of them do not have a jurisdiction clause in their contract which expressly states that.
Is that the DFC is forum non-convenience.
Sorry, I didn't get you.
What are you saying is that another court and the Omani courts is better suited to adjudicate this jurisdiction, this case, rather than the DSC court. So what you're saying is, because I'm still not convinced that the DSC court do not have jurisdiction just because there is no clause in the contract, because it's pretty much established authority in the DFC is that there must be on the explicitly opt-out clause in the contract to escape the jurisdiction of the DFC courts. So I'm not convinced that the DFC courts do not have jurisdiction, but I think what you probably want to say is that even though the DFC courts might have jurisdiction, then the Omani courts are better suited. That is sometimes defined as a forum convenience. You're muted, counsel.
Okay, so I would like to clarify one more thing. So it's between, like, if two individuals are having a contract among each other, then they need to expressly state that DIFC courts have jurisdiction. So in case of a dispute, then they would go for DIFC courts if they have. But but if there's an establishment located in DIFC, then by default DIFC law would apply, but only if it's an establishment or a company located in DIFC. So DIFC law would not apply by default to individuals. It would only apply to.
I think the issue here is letter B of Article 5A1, which is about transactions relating to a contract or promise, contract concluded, finalized, or performed within the DFC. So what I think you should address is why wasn't this contract performed or concluded in the DFC where the server was in the DFC?
Okay. Yes. So that is my second submission, which is related to why the transaction is not confirmed that it occurred in DIFC. So basically, my second submission is related to why the transaction could not have occurred in DIFC specifically.
Yes. Go ahead.
Okay. So can I go ahead with my first submission?
Yes, but I think on my end, I think we're mostly interested in your second argument. Unless Judge Santano refers to the first one, but I think in my view, your key argument is the second one.
Yes, I agree with my colleague. You should focus on the issue. Why do I might have jurisdiction? Any cause of action has happened. Come to a second submission. More relevant.
Okay. Thank you. Okay. So with that, Your Honor, this concludes my first submission for the appellant. My second submission is that the appellant and the respondent do not reside within DIFC, and there is no express clause related to jurisdiction in their contract. So the appellant and the respondent are not registered and have no presence in the DIFC, and hence the DIFC courts do not have jurisdiction. Moreover, the contract between Mr. Leith Payne and Ms. Razrani has not expressly stated that in case of a dispute, DIFC courts have jurisdiction. So I would like to refer to a case of Fetch.ai Limited and Persons Unknown Category A. So in this case, the court granted the claimants a proprietary injunction and a worldwide freezing order against persons unknown who had accessed their trading accounts containing cryptocurrencies and moved them out of the accounts. Bankers' trust orders and Norwich pharmaceutical orders were obtained against the companies that maintained the accounts. Permission was granted to serve the proceedings outside the jurisdiction on the defendants, as it was unknown whether they were within or outside the jurisdiction of England and Wales. And in the case of Corinth Pipeworks SA and Barclays Bank, this is the second case in the Court of Appeal in the year 2011, the Corinth Pipeworks SA and Barclays Bank PLC. So in this, the facts of the case are Barclays Bank has many branches across Dubai and UAE generally, and the claimant, Corinth Pipeworks, was trying to sue a specific branch of Barclays Bank, which was located in DIFC. However, however, the activity which was related to the branch, because of which Corinth Pipeworks was trying to sue, was located in Jebel Ali. But Corinth Pipeworks decided to sue the specific branch of Barclays Bank in DIFC. So in the judgment, Sir Anthony Coleman, the Deputy Chief Justice of DIFC courts, rejected arguments put forward by Corinth Pipeworks that the DIFC courts held jurisdiction over the matter. Lawyers on behalf of Corinth were attempting to sue Barclays at the DIFC court, saying that because Barclays Bank PLC was registered at the DIFC, its Dubai branches, including the one claimed to have assisted in an alleged fraud, fell under the DIFC court's jurisdiction. Lord Coleman said this argument was fundamentally defective. So what I'm trying to imply is that a distributed ledger and one of the nodes of Clevity was present at DIFC. However, there were many nodes present across the world, and it's not confirmed that the transaction took place specifically at DIFC. It could have taken place at any of the countries across the world, and since it's not confirmed that the transaction specifically took at DIFC, DIFC courts cannot have jurisdiction in this case. With that, Your Honor, this concludes my second submission for the appellant. I would like to invite Your Honor to overrule the previous judgment, and with that, Your Honor, this concludes my submissions for the appellant.
Thank you. Thank you. So, we'd like the respondent to rebut this. Mrs. Simon, Ms. Fatima.
Hello, my name is Fatima Marzi, and I'm the senior respondent of this trial. Your Honors, let me just very briefly summarize the situation. Due to Clevity is international, I'd say a national and an international platform where users could meet and to be able to make an agreement with each other. The respondent, Ms. Rani, and the appellant, Mr. Payne, were both users and were able to make an agreement with the platforms. Due to Clevity having a glitch due to their because of their routine upgrade, it especially with the disputed trade, this costed Ms. Rani $250,000 US. But she did not know anything about that, and she, I believe that she, according to Article 37, subsection 1A of the DIFC contract law, that Ms. Rani only knew the circumstances and the knowledge around her platform and Mr. Payne's platform, and did not know about the disputed trade and what she will do about it.
Thank you, Ms. Zara. Apology to interrupt you. I believe we already had an exposure to the factual framework by counsel for the appellant. So since I think that you're making a submission of jurisdiction, it would be helpful if you could point us to any aspects of the factual reconstruction you want to clarify specifically rather than repeating what was already said?
Okay. Miss Ronnie believed that due to that the only reason why she had she needs to pay $250,000 was because of an error caused by the cavity and the disputed trade. And I'll leave the floor to my colleague, Mr. Simon. To
Ms. Fatima, again, this, if you know, the scoring sheet is like 10 points for each council. So that's how it is assessed. So if my colleague, Mr. Rodrigo, is okay with Mr. Simon going ahead.
Yes, Mr. Samuel, you can go ahead.
Yeah.
Thank you, my lords. My lords, the case of the respondent whom I'm representing today is on two grounds. So the respondent is rejecting the two grounds of appeal which has been put forward by the appellant. It is the respondent's case that the DEC court had jurisdiction to determine this matter as a first instance court. The reason for this is that the DEC court has jurisdictional powers under Article 5A1B of the Judicial Authority Law, Dubai Law number 12 of 2004. It is the case of the respondent that Article 5A1B is broadly interpreted. This is supported by the recent case where the DIFC court has granted an injunction for a case to continue within the DIFC jurisdiction. And that case is the case of William Allen Jones, Coffee Planet LLC, Coffee Planet's Roastery FZE, and Robert Anthony James. This case reaffirms that this court has broad jurisdictional powers under Article 5A1B, and that is also affirmed by the case of Al Kharafi and Bank Saracen. And so it is the respondent's case that the DEC correctly concluded that it had jurisdiction to have heard the matter between the dispute between the respondent and the appellant. My lords, I'd like to make the point about the meaning of a node. A node is a point in a network or diagram at which lines or pathways intersect or branch. It is said in the facts and is common ground that the parties are well aware or agree that the platform they use, which is Clavity, had one of its nodes operating within the jurisdiction of the DIFC. Under Article 5A1B, the DIFC court will have jurisdiction over civil or commercial claims that have been fully entered into or partly entered into or fully concluded or partly operated within its jurisdiction. The essence of the node is to assist the Clarity platform, which operates as a distributed ledger. So without the Clarity platform, the cryptocurrency exchange wouldn't have taken place in the first place. So it plays a central role. And because it is within the jurisdiction of the DFC, the DEC court was well within its rights to have found that it had jurisdiction. And that concludes my first.
Counsel, I'm sorry. Could you please clarify two things? So first, you cited, I believe correctly, Article 5A1B. But 5A1B has various hypotheses, right? So it talks about contracts concluded, contracts finalized, contract performed, contract promised. So there are various factual hypotheses in that particular provision. So which one is it here? Was this contract concluded in the DSC? Was it performed in the DSC? What part of the article are you referring to?
My lord, thank you. I'm referring to where it says contract partly or wholly concluded within the IFC, and also where it says contract which will be performed or is supposed to be performed within the DIFC pursuant.
Okay, so which one is it? So what are you, I mean, so are you saying that this contract was all of these things? So this contract was concluded in the DSC, was finalized in the DSC, and it was performed in the DSC. But what you're saying is that all these four different scenarios are applicable here.
No, that's not my point, my lord. My lord, my point is that this contract was concluded, partly concluded within the DIFC because of the relevance, the input of the node, which is used in the Clarity platform.
But counsel, where the parties reside in the DSC at the time of the contract?
My lord, based on the facts now, one of the parties reside within Dubai, but outside the jurisdiction of the DFC, and the other party resides in Oman.
Yes.
However,
how is it possible that parties outside the DFC then conclude a contract in the DFC?
Because a contract where it's performed. So when I say conclude in this instance, I mean where the contract is performed. The contract was partly performed within the jurisdiction.
So then you admit that it was concluded outside, but then it was performed inside the DSC.
Partly performed within the DIFC, yes. And that would meet the criteria under 5A1B. That would be sufficient.
So what you're saying that the fact that the server is in the DSC means that the transaction happened where the server is. The exchange of the security took place where the server is. That's what you're saying.
Indeed, my lord. So the transaction would have taken place in most cases at worst partly taken place, because it wouldn't have been possible to take place without the server working anyways.
Thank you.
Thank you, my lords. My lords, if you're content, I will then move to the second ground of appeal.
The second ground, the appellant must argue first, and then you can rebut that.
Thank you, my lord.
Okay. So we invite the appellant to come up with the second issue.
Okay. May it please the court. My name is Daniel Osas Ibosa. I'm the junior appellant of Payan. So I would like to state my second ground of appeal. Disputed, thank you. Disputed trade was not a result of the error. The judge also held in concluding that the disputed trade was a result of error. If you may plead, my lord, I would like to give my first submission. Thank you. The doctrine of freedom of contract states that individual of full capacity being able to freely choose who they contract with and of what terms within the contract. This began in the 19th century when judges believed that people should be able to make their own decisions since they know that it is best in their interest, under the assumption that nobody would choose on favorable terms. One second, please. I don't know what is happening. Okay, I'm still here. Okay, thank you. Thank you. On favorable terms, the court simply acted as an umpire, ensuring parties were upholding their promises. They only interfered in special cases, including those involving in misrepresentation, undue influence, illegality. In this case, there was no misrepresentation, there was no undue influence, there was no duress, and there was no illegality. So we see that in the case of PSGB versus Boots in 1953, if you may plead, my lord, can I give the brief of the case?
Yeah, please.
Thank you. In this case, it shows that once an offer was accepted, the contract is completed. Then in this very case, there was an offer of 100 Yapo. There was an offer of 100 Yapo by my client, which is Payan, and it was accepted by Alpha, which is algorithm programmed by Mrs. Raji for $25,000. Both the appellant and defendants are adults. They are both adult and of a sound mind who programmed this algorithm by themselves. Thus, they were also competent enough to know about the risk of trading volatile product, which is crypto. Okay, so I have a case here of Adams versus Lyncher in 1818. If you may plead, my lord, to give the brief of this case.
Please.
Thank you, sir. In this case, it says that once claimant paid that amount of money, she accepted the offer. So then there is a valid contract. As such, I'm trying to understand why we are actually still back in court, or why we are in court when there is a contract. If you would please, my lord, can I give my second submission?
Yeah, please proceed.
Thank you. I would like to establish on Article 43 of the DIFC contract law regarding the loss of a right to avoid a contract. State, and I quote, if a party is entitled to avoid the contract for mistake, but the other party declares itself willing to perform the contract as it was understood by the party entitled to avoidance, the contract is considered to have been concluded as the later party understood it. The party entitled to avoidance had understood the contract, and before that party has acted in reliance of a notice of the avoidance. Moving forward with this, we have a case of Hentron vs. Fraser, which is 1892. If you may plead, my lord, to give a slight brief of this case.
Please.
Thank you, sir. In this case, the claimant could not revoke the contract after there was an acceptance because it was valid contract.
But is this a case of mistake, counsel? Can you tell us why this case is relevant? Was the issue of mistake?
Yes. Okay, thank you. So because they are coming up to say there was a mistake, that is to say they were, because if you actually check the fact of the case, they both know what they were doing. Our client was trading and their client was buying. So they
weren't they sleeping? Weren't they sleeping?
Yes, when they were sleeping, but they said the algorithm of what the trade should be. They are both experts. So they both have a sound mind to know what they are doing. This is not their first time of trading. They are in business. So, if may please, my lord.
So you are saying that it was known to the respondent that should be shelling out around 250 times more than what is the normal price.
Okay, thank you, my lord. If I'm saying it is reasonable, fair, and just for anybody to come in and buy crypto the way we program it. So moving forward, if anybody should be held reliable, it shouldn't be us, it shouldn't be our client. Instead, it should be Clarity, not our clients. Because we program our algorithm, they program their algorithm. So in order for us to see that one, we were able to establish the fact that there was no mistake and there was a contract. And once contract is done, in as much as there was no unilateral mistake, in as much as there was no common mistake, in as much as there was no mutual mistake, it becomes a valid contract. If it will please my lord, can I continue with my third summation?
Please.
Thank you, sir. I would therefore establish that the fact that the other party has lost the right to avoid a contract. Pine sold his 100 coin crypto coin for $250,000. Raji's obligation under the contract is to pay $250,000. Since Pine is not avoiding or terminating the contract, we consider the contract to have concluded. That is the same issue we're having. This is a concluded contract. I don't know why they still have to establish the fact that there is a mistake in it, which we don't believe that there is a mistake.
Counsel, sorry, can you conduct us through how the payment was made? My understanding is the payment was made automatically.
Right. The payment was made automatically, but I have a case to put up with this. Because I just want to be able to establish a case relating to my claim, stating that there must be an implied obligation. That is a case of Duelia versus 4 Mill Bank in 1978. There is a case that said this must be an implied obligation on the part of the offeror not to prevent the condition being satisfied. An obligation which arises as soon as the offeree starts to perform. Until then, the offeror can revoke the whole thing. That is to say, I'll move forward. Before then, let me explain this little paragraph. If
counsel, isn't this case about the conclusion of the contract? My understanding is that this case you're referring to refers to a case where a party revoked acceptance before it was crystallized. I think our case is different here. There is no question that the contract was concluded. The question is whether the parties concluded the contract in error.
We are establishing the fact that it was not concluded in error. That is why we are trying to establish what is even a contract. A contract is an offer and acceptance. In as much as there is an offer and there is an acceptance, our client is in business. So we cannot be held reliable. We cannot be held liable for Mrs. Razi, probably, let me not use the wrong word, like negligence or her inability to know what she's doing, even when she claims to be sleeping, yeah, when she's sleeping. But the thing remains, the fact remains, in as much as there is a contract, it cannot be revoked. So we are, if the claim is an error, we
Counsel, can you point us into the contract law where the issue of negligence of the parties seeking to avoid the contract is relevant?
Sorry, we want to say that again, please.
You mentioned negligence, the principle of negligence. Is this part of the assessment of mistake for the purposes of the DSC contract law?
Okay, if we have to go through Article 37 of the DIC contract law, I read and I quote: if the other party made the same mistake, or was also mistaken, or caused the mistake, or knew, or ought to have known of the mistake, and it was contrary to reasonable commercial standard of fair dealing to leave the mistaken party in error. It was not our mistake. Even if a mistake is being established, it was not our mistake. We didn't cause the mistake. There was no misrepresentation. There was no inducement. There was no fraud. Everything was done with a clean mind. We are in business. We set up our client set up his algorithm. The other party is the business who is a specialist, set up her algorithm. So if anybody
counsel did your client so understand that your submission is that the appellant was wrong, or better, sorry, was negligent in assuming the risk and essentially sleeping while the platform was working, and accepted the risk that an incident such as this one could happen.
Okay, if I must say, if we have to look through negligence, first of all, my client does not owe Mrs. Raji duty of care. And we all know for a duty of care to be established, it must be fair, reasonable, and just.
Now, what my colleague is trying to tell you is that where is the negligence committed by the respondent?
Okay, sorry. Let me assume I understand the question. Your question is, where is negligence committed by the respondent? Is that your question,
because
please?
You argued that we are not responsible for the negligence of the respondents.
Yes. My point is, we are not responsible for any consequential loss, probably suffered by Mrs. Raji, because we set our algorithm to sell higher. She set her algorithm to buy lower. But if there was a maintenance on the side, Clevity should be, and that caused all this situation, Clevity should be held liable and not our clients.
So you're saying the respondent was not negligent. It was because that's why Clevity should be held responsible.
Right. Clevity should be held responsible and not our client.
Counsel, I think I'm not sure the case here is whether or not Clevity was responsible. The appellant may or may not have a case against Clevity, but or your client might have a case against Clevity, but I believe that would be a matter for a different case. The case is, I think here is just between these two parties and whether this contract was entered mistakenly by both parties. So I don't think whether or not the parties have an action against Clevity is relevant.
Okay, thank you, Your Honor. So our client is not liable. The reason why we're shifting liability is simply because there was a contract on our end, which is a valid contract, and the contract was not entered by mistake. So no, there was no mistake in the contract. That is our argument.
Thank you.
Okay, thank you. Can I, if you may please, Your Honor, if you may please your Lordship, can I proceed?
Proceed.
Thank you. So, if it may please my Lordship, I would like to conclude my summation.
Yes, please.
Okay, if it may please my Lordship, I would like to invite the court to rule in favor of the appellant. With that, Your Lordship, this conclude my summation. Thank you for the appellant. Thank you.
Thank you. So, Mr. Simon.
Yes, my lord.
Yes, proceed.
Thank you, my lord. My lord, I will now proceed to the second ground, which the appellant has brought before this court. My lord, the respondent rejects the second ground. My Lord, it is the respondent's case that the DEC correctly determined this case when it heard the case without having to assess the state of mind of the programmers. The reason for this is because it is trial law that general principle of contract is that a contract should be, the test for assessing the intention of the parties is an objective one. And I would like to support this proposition with a couple of authorities. The first authority is the case of Smith and Hughes. It's an English law case. So it's a common law case where, according to Blackburn J, he said, if whatever a man's real intention may be, he so conducts himself that a reasonable man would believe that he was assenting to the terms proposed by the other party, and that other party, upon that belief, enters into the contract with him, the man thus conducting himself would be equally bound as if he intended to agree to that party's terms. Essentially, what Blackburn J was getting at, the point he was making, is that it doesn't really matter what a party to a contract subjectively think. What matters is how a reasonable man who has been given all the background information regarding that particular contract, how they will view that particular contract. And so the DEC court, the DEC was correct in coming to the conclusion that it did not have to carry out a subjective approach of assessing the state of mind of the programmers, but what it was required to do under Article 37(1)(a) of the DIFC contract law was to apply an objective interpretation. And in doing so, it rightly found in favor of my client, which is the respondent. My Lord, I reiterate that it's sufficient that a reasonable trader with knowledge of circumstances surrounding the transaction would have concluded that this disputed trade was a result of error. And I say that for two reasons. First, it is common ground that there was an error because both parties accept that the Clevity platform, which their individual programs were attached to, malfunctioned. And once it's malfunctioned, a reasonable man would view it that the original contract which was entered into has changed the course of direction. And so once it's changed the course of direction, it's lost its commercial purpose. Because as we see from the facts, the exchange that took place was 250 times higher than the above market rates. I'm afraid that I'm not persuaded by the counsel for the appellant that you would find someone, any reasonable person, who would agree that they would conclude a transaction 250 times higher than the market rate. Because what's the essence of a transaction of this sort, exchanging cryptocurrencies, selling and buying? It's for commercial purpose. And here we are with a case where the commercial purpose has been lost. And once the commercial purpose was lost, the contract...
Counsel, sorry to interrupt you, but it seems to me that your pleading is not about mistake, it's about hardship. So what you're saying is that since the transaction was so inconvenient and the price was so inadequate, so much higher than it should be, then the contract should be revoked. But I don't think that is the issue here. There is no hardship clause in the contract. So if the parties decided to enter in the contract and accepted the risk that the price may be determined in a way that does not correspond to the market price, why will that be sufficient to escape the enforcement of the contract?
Thank you, my lord. My lord, my point is that there is common ground that there was an error. And my point is that that error was material. And that error has caused a material mistake. And once it's caused a material mistake, it's deprived the contract of its commercial purpose. I take you back to Article 37, 1A of the DIFC contract law, particularly to the clause that says, or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. I take the point that the appellant was asleep, just like the respondent, and didn't do anything actively to change the course of direction of the contract. However, the appellant, at the point where he has now been informed that the Clavity platform malfunctioned, ought to have known that there was a mistake. And indeed he did. He does accept that there is a mistake. The platform malfunctioned is common ground. So the second limb of that clause under Article 37 is that the respondent, which is my client, will be able to not be made to perform this contract if performing it will be contrary to reasonable commercial standards of fair dealing. Essentially, what this statute does is that it has written into law the principle of good faith. And so, even though this is a business-to-business transaction within the DIFC jurisdiction and under Article 37, is very crystal clear that there is requirement to trade fairly. So where the appellant now
sorry, counsel. So what you are saying is that the other side has not traded fairly? Why is that?
Because the others, the appellant has accepted, since it's common ground, that actually there was an error on the Clavity platform. And from that point,
but the question is not whether the platform malfunctioned. It is undisputed the platform malfunctioned. The question is whether the fact that the parties were sleeping while the transaction happened represents an error for the purposes of Article 37.
My lord, can you rephrase your question once more, please?
I think your case, your argument is about Article 37, right? So
yes, my lord.
The question here, and we raised, we clarified with your learned friend that their submission is that your client was negligent in having her money working while she was sleeping. So why wasn't she negligent? I mean, the point that at the moment an investor decides to invest capital into the system and put money into Clavity and sets automatic trade, didn't she accept the risk that accidents such as this one could happen?
Thank you, my lord. My lord, I'll disagree with the point raised by the appellant that my client was negligent, because if we go to the words of Article 37 2A, it says However, a party may not avoid the contract if it was grossly negligent in committing the mistake. First of all, the mistake wasn't the doing of my client, of the respondent. It's common ground that the transaction was conducted in an automated manner. Both parties were sleeping. And so that first claim of whether he as a party was grossly negligent, the mistake wasn't her doing. And if it wasn't her doing, there's no way we can satisfy that she was grossly negligent. And so that point,
counsel, in the practice of trading, for example, I'm not sure about Clarity, but certainly is in other platform. When a trader can set an automatic trade, then there is also a function called stop loss, right? So your client could have set a stop loss order so that accidents such as this one could not take place. Isn't that negligent?
My lord, I understand your point, but this is a case that rests on specific facts. And the relevant fact here to answer your question is that indeed my client had some sort of liquidity to set a stop loss. Clarity, as we know, has a limit of 50,000, minimum 50,000 USD. My client had 50,000 USD. And so what is an issue here is whether there was a malfunctioning. If this was a different occasion, so if the platform had performed without any malfunctioning, then I think I would agree with the point you're raising, my lord. But in this instance, the platform, it is agreed, operated whilst malfunctioning. And so once every party is aware that it malfunctioned, every party should, as a matter of the good faith principle under Article 37, accept that the contract has lost its commercial purpose. Because
so counsel, sorry to interrupt again. So what happened in this case is that the security was sold at a much higher price than it should have been because of a malfunctioning, right? So yes, what if the same had happened, not because of a malfunctioning, but because, for example, of an unforeseen event? So let's say a market event, for example, the crash of another crypto entity, or the IPO, for example, another entity that raises the price. So it could have been, there might be market events that for some reason raise the price overnight, and we have seen this in the history of cryptocurrencies. So are you saying that if the change in price, rather than being due to a malfunction of the platform, would have been due to market events, for example, then there will be no mistake?
My lord, I agree with you in part. Obviously, cryptocurrency is a sector where volatility is not a stranger. And so, and cryptocurrency trading is similar to stock trading. So, there are market responses throughout the day or during the trading period. And volatility is something that all traders oftentimes are well aware of. But the point I'm making is that this is not one of those situations. If this is not one of those situations. No, you couldn't factor in malfunctioning. This is a case of force majeure in a way, because once it's malfunctioned, there was no contract at all to be performed. The contract was agreed, having in mind.
Let's stick, counsel, let's stick on a mistake. Force majeure is another type of. First of all, are you relying on any provision of force majeure in the DC contract law? Are we still talking about mistake?
I would like to add that as an alternative okay, for my clients. If you allow me to progress.
Yes, please go ahead.
Thank you, my lord. So having established that there is a mistake which all parties agree to, and once the mistake took place, transaction concluded in error, and as a result, the contract lost its commercial papers, and so the court was right to make its assessment, taking an objective approach. I'd also like to draw the minds of my lords to a couple of cases. First is the case of Nicole Knight and Ashton, Elridge and Co., 1901 case of King's Bench Division in England. My lord, I'll give you a brief background to this case. So this is a case where the contract...
Sorry, please, sorry to interrupt again, but are you still talking about mistake or you talk about force majeure here? What is this argument about?
My lord, I've progressed to the second, the alternative point, which is force majeure.
Okay, thank you.
Thank you, my lord. So, my lord, this case is a contract where the parties agreed that a cargo of cotton seed was to be shipped from Egypt to England. The contract specified the ship, the Orlando, which was to carry the cargo. This ship became damaged and was in for repairs when the contract was due to be performed. My lords, in this case, the court held that by naming the exact ship which was to carry the cargo, the contract was frustrated as it was impossible for the ship to carry the cargo within the contractually agreed period. If we take that principle and impute it into today's case, into the case at hand, by describing and by subscribing to the terms of Clavity platform that you should have 50,000, so there was a reasonable expectation that you could exchange up to 50,000 if there is a fluctuation in the prices of cryptocurrency. Both parties have given the impression or signposted that they're limiting their risk. And so it would be unfair to expect my client to then suffer anything beyond £50,000. There's also the case of Krell and Henry. This is a case where the defendant hired a flat on Pall Mall for sole purpose of viewing King Edward VII's coronation procession. The price agreed was £75 for 2 days. The defendant paid £25 deposit. Due to illness of the king, the coronation was cancelled. Consequently, the defendant...
Counsel, aren't these cases, I know, and I'm sure also Judge Santano knows very well those cases, but aren't those cases about frustration rather than force majeure?
My lord, permit me to
make it simple, which part of, if you have several issues, one second, I'm sorry, Mr. Simon, like force majeure is covered by various aspects. So which part of it is applicable in this particular case?
My lord, permit me to readjust, my argument, if you may wish, to frustration, that the contract was frustrated. That was the second point I wanted to make, actually, not force majeure. If you're content, I will progress.
Please.
Thank you, my lord. So in this second case, the court held that the contract was frustrated as cancellation of the procession deprived it of its commercial papers. And then the final case I would like to make reference to is the case of Hartog and Collin and Shells, where...
Thank you for the authorities, but counsel, I think the basis here, since the DFC is a common law jurisdiction, and English law, it is relevant to the extent that the DFC law does not cover a particular issue. But the starting point should always be the law and the contract law in this case. So can you please direct us to, since you're pleading frustration now, where frustration is addressed in the DFC contract law?
My lords, I do not have those in handy, and if you permit me, I can come back to address that point. But I'd like to conclude that the court was right in taking an objective approach to conducting an assessment rather than taking a subjective approach to making its determination. Thank you, my lords.
Thank you. Mr. Rodrigo, can we confer separately a bit?
Yes.
So I think the process is, I think we have to leave this and then...
Can we go to the breakout room?
Yeah. Okay.
Are we finished? No, we still, okay.
I think we have finished here.
Okay, but we should give, I believe we should give feedback to the teams before leaving for deliberations.
Okay, you can start.
Yes. Okay. I'll give a general impression. So, it's was very well done presentation from both sides. You know the facts really well, and I will say all of you can be charming advocates. You're very very convincing in the way you put arguments before the court, and you have charisma as advocates, which is a blessing and will be in your future as professionals. Regarding the substance, I think you might want to, before preparing your arguments, to read up the law and read. Right, there is a rebuttal. Yeah.
Yes. Also, I just want to add, Ms. Fatima, we are meeting again for the second time today. So you have to be prepared when you are coming in this forum and arguing a matter, whether it's a moot court or whether it's actual court. You cannot delegate to your colleague because you are designated as a counsel here, whether senior or junior. So you have to take care of that, because when you nominate yourself or you are nominated, that time you should provide clarity whether you will be able to handle it or not. This is keeping in mind the future also. You are all budding lawyers. So obviously we'll be happy if all of you become good lawyers. So that's what I think Mr. Rodrigo will also agree with me in that aspect.
Yes, thank you. And in general, so the last remark will be, understand that we all come from different legal systems. I personally come from a civil law, my system. So we're all reading up the law, and we are learning about the law of the DFC, which I think is based on the common law, but has its nuances, and a straight referral to English law is not always helpful, because really DFC, I think, in many ways is a cross jurisdiction between the common law and the civil law. But what is important is you're clear in your arguments. So frustration, force majeure, mistake, all these figures are there different rules. They have a different source in the DFC court rules, DFC law, and you need to be clear to what you're talking about with the court. You cannot mix up everything. So facts are important. It's important to make your case, but what is even more important is to be clear with the court what your argument is about, and expand that particular argument before going to the next one. Sometimes, and I think for everyone, sometimes the impression that you will mix up arguments, mix up different provisions of the law. Every provision that you rely on deserves a proper argument, distinct argument. That's all.
we have a message from the appellants wanting to have a last go at whatever Mrs. Simon has argued. So I think we have 2-3 minutes. We can give them 4-5 minutes, whatever the maximum.
Yes, 5 minutes.
Yes, Mr. Mohammed, you can start.
Good evening, everyone. So my learned opposing counsel, Mr. Simon, talked about the force majeure clause. The force majeure clause is not incorporated according to the facts of the case. The force majeure clause was not incorporated into the contract. So there is no question of force majeure clause when it is not incorporated into the contract. I would say that. And I would like to direct my opposing counsel, Mr. Simon, to to Article 37, Section 2 of the DIFC contract law, which states that a party may not avoid the contract if subsection B, if the mistake relates to a matter in regard to which the risk of mistake was assumed. So what I'm trying to imply here is that cryptocurrency is a volatile product. So the price increases spontaneously, and within minutes the price increases spontaneously. So since it's a volatile product, the Ms. Rajrani should have known the risk before getting into trading of cryptocurrency.
No, but Mr. Counsel, the issue here was the platform. There was a malfunction. It was nothing about price going up or price going down for market control.
Okay. And I would also like to state that the program created by Ms. Rajrani, which was called the Alpha, it was not competent enough to tackle all situations and circumstances. Example, in this circumstance, when all other market users were excluded from the market except Ms. Rajrani and Mr. Leith Payne, the program Alpha was not competent enough to tackle this situation, and thus Ms. Rajrani faced a humongous loss. So, and it's not a mistake of our client, my client, which is Mr. Leith Payne, and since it's not a mistake of my client, Mr. Leith Payne, the contract cannot be held void for mistake. So, Your Honor, that concludes my rebuttal.
Thank you. Mr. Rodrigo, then we go back to our room.
Yes, we go to the breakfast room. Yeah. Thanks, everyone.
Thank you, gentlemen. Thank you very much, and best of luck for tomorrow. Thank you.
Thank you, my lord. Thank you. Bye-bye.
Bye.
Thank you. Bye.
Thank you. Bye.